You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 93. Be careful what you title your design patent application. My name is Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at diamondpatentlaw.com. That's DIAMENT patentlaw.com, or call me at 424-281-0162. In this podcast, I really try to focus on the process of trying to get a patent, so drafting the application and corresponding with the patent office. I don't really go into current topics or cases in patent law, for the most part because these cases right now deal with some particular minutia of patent law, and I really want you to see the forest for the trees in this podcast. And there are also lots of other podcasts about intellectual property cases and current topics, and it's not really my focus, but I do want to talk about a particular case that just came up a couple of weeks ago because I think it's actually really relevant to drafting your patent application. The case is Curver-Luxembourg, SARL, versus Home Expressions. And I'd recommend that you actually look at this patent. So go to Google Patents or Free Patents Online and type in D677946, and it's called Pattern for a Chair. Now, because it starts with D, you know that this is a design patent. Most episodes in this podcast are about utility patents, which are about patents about how something works. But I did talk about design patents a little bit, and it hasn't really been a focus, but you should be, aware of them because many of you are probably interested in design patent applications. And if you remember when I talked about design patents, what I told you was that the drawings are your invention. When you write the claims, there's just one claim, and you say what you're claiming is the ornamental design as shown and described, and that's it. The hard part about design applications isn't the claim, it's knowing how to do the drawings right for you to get maximum protection. What I've also told you is that in general, the title isn't going to make much of a difference, but it should still be a broad title. And saying the title doesn't make much of a difference should still be true normally, especially for utility patents. But I'd still recommend you having a broad title because you don't know what will happen in the future in some case, and someone will argue that the title of your invention limited your invention to that particular use of it. So if you came up with a new remote control, maybe you titled it Remote Control for a TV, but someone came up with a remote control that was the same, but their remote control wasn't for a TV, but was for a printer, let's say. Now in theory, if the claims don't specifically mention that a TV is part of the invention, then the title shouldn't make a difference, and it doesn't matter if someone used your remote control for a different use. Now I still wouldn't recommend that in your title or preamble to the claim saying it's for a TV, because it could probably only hurt you and not really help you in any way. But there was a big case that just came out about the title and language in a design patent and whether that limited the claim. And the Federal Circuit said that the title and words in a design patent do limit your invention. It's not just the drawn figures. If you don't remember what the Federal Circuit is, if you ever sue someone for patent infringement, and if you want to appeal that, then you go to the Supreme Court. Now, the Supreme Court takes so few patents, the Supreme Court are really low. So in a way, for most things related to patents, the federals are just extremely low. So if you look at this patent, it's titled Pattern for a Chair, and there are 5 figures. But none of these figures actually show a chair. All they are like patterns for a stitching. This is called like a rattan. It's just a type of weaving that, certain types of wood or other articles, it could be plastic that's made into. It's not really stitching, but it's more about how the plastic parts are just kind of put together where there's overlapping and underlapping pieces. You should just look at it. It's hard to explain, but if you look at it, it makes sense. And if you look at the brief description of the drawings, it says Figure 1 is a front view of a design for a pattern for a chair. Figure 2 is a top view of a design for a pattern for a chair. And it just goes through the same for all 5 figures. So they get a patent for this. Then someone comes along, uses this pattern, but doesn't use it for a chair. They use it on a basket. And the question is, are they infringing? Now, if you just look at the figures, you say, yes, they're using the same design of this patent. But if you look at the words in the title that says design for a chair, and the basket makers didn't use this pattern on a chair. So the question is, do we take into consideration the title and the words in a claim that mention a chair when determining the scope of protection? Is it just the drawing as shown in the figures, or is it the drawings and the figures and how they must be used on a chair? And the court said that the words of the title and the claims are important in determining the scope of the invention. So the words also matter in a design patent. And because of this, if people use this design that was patented, but use it on something that was not a chair, they're not infringing. So the moral of the story is, be careful about what words you're using in your title and description in a design patent application. Now, maybe you're wondering, why do I have to say what the design is used for at all? Why couldn't the inventors just say their title was overlapping pattern and made it really broad? Actually, when they filed this in the beginning, they did make it broader. They called it a furniture part instead of a chair. Now, maybe that wouldn't have helped in this case because the basket is still not a furniture part. That's maybe yes, maybe no. A little bit of a gray zone. But let's say someone made a dresser using this pattern. If they had furniture part instead of chair, people that made the dresser would still have been infringing. So why do they have to narrow it at all? And it's because there's a rule in design patents, and it's found in 37 CFR 1.153, if you want to look that up. And it says, the title of the design must designate the particular article. So the examiner objected to furniture and said it had to be a particular article. And saying something is a part or part of something is too vague. And the examiner suggested using pattern for a chair. And the applicant amended their application so that everything said pattern for a chair. Now, they probably had no idea of the ramifications of this. But on the other hand, if the examiner is saying they had to change it, and maybe they only had a chair that they were putting this pattern on, and they didn't want to argue with the examiner saying, no, furniture part is fine, then what else could they have done? So they made these changes and it got allowed. And the claim said ornamental design for a pattern for a chair, as shown and described. So it all comes down to, what is the invention? Is the invention just a pattern? Or is the invention the pattern specifically on a chair? Is the for a pattern for a chair just kind of superfluous words describing what it could be used for in a chair? Or is the patented invention specifically a chair pattern design? Now, as I mentioned, the court said that the words in an application make a difference. So if it's not on the chair, just using this design isn't enough. Now, the court specifically said that the scope of a design patent is limited to the article of manufacture listed in the patent. And in the original court, the district court said that an ordinary observer would not purchase Home Expressions basket believing it to be a chair having the same pattern. Then Curver appealed and said that the district court was too limiting because the figures didn't illustrate a chair. So just having those words shouldn't make any difference. The illustration is what the patent is. The Federal Circuit said that you can't just get a design patent for abstract surface ornamentation, and that patents have never been granted for just abstract surface ornamentation. It had to be with a particular article of manufacture. So this was actually the first case where all of the drawings failed to depict an article of manufacture for the design. And the court said that design patents are only applied to an article of manufacture, even if none of the figures showed that particular article of manufacture. I'm not really sure what advice I can give for the future if you're thinking about doing a design application, except to try to be as broad as possible in your title and description. Now, they tried to be broad and say it was a furniture part, but the examiner said they had to be more specific. So maybe in this particular case, they couldn't have done much better. But let's say that you have a particular fabric weave, and the fabric is an article of manufacture. So if you have a fabric design, and I do see there is a patent number D785340, and it just says fabric. That's the title of it. I see another one called Design for Textile Fabric, which is D97416. Let's say you only put this fabric on chairs. Should you write in the title of your invention and describe it as fabric for a chair or just fabric? You probably don't want to put a chair in the title or the description because that limits the article of manufacture. Someone might make curtains out of your patented design. And if you had put in chair, then according to this case, they might be able to get around your design patent. So I guess the final moral of the story is to try to be as broad as possible as you can in describing your article of manufacture, because the words in a design patent can be used against you. And if you want help with your patent application, trademarks, copyrights, responding to rejections, appeals, or anything else related to your invention, you can contact me directly through my website at diamondpatentlaw.com. That's DIAMENT. patentlaw.com. Email me at adam@diamondpatentlaw.com or call me at 424-281-0162. I'm Adam Diamond, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com, or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.